little bit more time to put it for you guys together. So today I'm going to cover other problems. It's more contractual problems, GST issues, holdback problems. So I'm going to cover this today, and we do separate portion track. Doesn't sound good? Contractual problems, GST issues, holdback problems. So I'm going to cover this. Can you hear me well?
Yes.
Mm-hmm.
Yeah.
So, okay, perfect. Whenever you're ready, and I can share my screen.
Yeah, we are live on YouTube now.
Can everybody see my presentation?
Yes.
Perfect.
Yes.
All right. Again, thank you for having me, guys. And today I will be presenting on quite interesting topics. This is more for real estate agents, oriented to ensure that you spot potential issues when you see contractual issues. So my name is Natalya, and I'm owner of Uptown Notaries. So I'm going to cover those today, that who we are, what we provide, contract clauses. We're going to cover special levies, holdbacks. We're going to talk about GST and property transfer tax issues, what to look to avoid disputes and potentially litigations. I'm going to ask you a question if you know a difference between notary or lawyer for real estate, and just will share some information about us. So Uptown Notaries, we've been established since 1992. As of today, we have 2 locations, and we cover, our first location is in Burnaby and New Westminster. We also provide mobile service and signing appointments in Vancouver and Langley areas for real estate transactions. We speak different languages, Russian and French. And here is just some other achievements that my company had over the recent years. About me, so I have a law degree overseas. I got a litigation experience as well, graduated master's program at SFU, and since 2018, I'm an owner of Uptown Notaries. I've been featured by SFU as one of the successful graduates. I'm active networker, mom of 3 children, and I live in Coquitlam. So that's about me. Very quickly, our services, of course, cover any transactions with real estate, whether it's purchase, sale, refinance, foreclosures, leaseholds, mobile homes. I do a lot of estate planning, and I do lots of private lending, which means I act for private lenders. So let's dive in. To cover some logistics, maybe if I can know a little bit, how many real estate agents in the room are within their first 2 years of practice? Hands? Not everybody on camera, so I can't see that, but this is something that
I'm trying to fix my camera right now.
Okay. So we've seen quite often that, and it's quite a standard practice to send a contract to a law or notary firm once a subject's removed, right? But it's a good idea to think ahead that the closing solicitor would need these documents minimum 7 days before completion day, and preferably before. And you all know why, right? Because there is also a lot of work happening in the office to prepare all documents. So most firms consider file to be accepted once the contract of purchase and sale is received. So tip for you here, you can send it even if the subject is not removed. So at least it's already goes in the firm, it's in their schedule, and then just let them know that subjects are removed, so proceed. So that's a better approach. Package of documents, right? There is different documents floating around, depends whether it's a documents to the buyer's office, to the seller's office. I'm sure you're all familiar with that, and I'm not going to spend a lot of time. But what's important for that, if let's say you're acting for the buyer, include, and if it's a strata property, include Form B in the package. So if it's not expired, right, we can still use it and save some money to your client, right? If it is expired, we'll have to order a new one. If you pulled any non-financial charges on title, also include them. So because as a part of the due diligence process, it is recommended to pull those before subjects removal. So we don't want really to be in a position when before one day of the completion, we're sitting with a client and they have no idea what are those charges are. We will offer them to pull them, but of course, if you done it on your end, it looks good. So one of the biggest, I would say, problematic clauses that we see is the strata levy. It is always, if the contract is not clear, it's always a dispute. It can provoke a dispute in the future. Who actually pays it? So here's an example for you on a strata. So contract was silent on this, and that was a strata resolution. I will read it for you. Be it resolved that owners of X village vote by special resolution to approve a special assessment of 180K in total to cover the costs of water ingress and drainage repairs. Each strata lot special assessment will be in accordance with its unit entitlement and will be due and payable immediately, and not later than there's a date for that. Payment will be made in 2 installments. First payment, or half of the assessed amount, by May 21st, and the remaining portion by August. A list showing each strata lot special assessment is enclosed with this notice of meeting package. So the problem here, who really pays it, buyer or seller? And when a contract is silent on that, then Strata Property Act applies, right? And I'm sure you already familiar. If not, let's refresh your memory about Section 109 of Strata Property Act, that if a special levy is approved before a strata lot is conveyed to a purchaser, right? So it's really clear who pays it. So by default, we're gonna look at the Strata Property Act. But at the same time, you all have this list of clauses that you play with. In most of the contracts, we see that real estate agents are doing a great job of protecting their client by putting those clauses like this one, right? It's quite a standard clause that we often use. If a special levy is approved before the completion date, the seller shall credit the buyer with the entire portion of the special levy that the buyer is obligated to pay under the Strata Property Act, and the seller hereby directs the buyer's lawyer notary to hold back such credit from the sales proceeds and to remit it to the Strata Corporation. But in this case, it wasn't enough. So that was a deal that I had, and we had this contract with this clause. In these transactions, we were not able to hold back special levy from the seller because of the wording of the contract. Special levy was proposed, but not approved by the strata. So it became responsibility of the buyer to pay it at the time of closing. So when you choose those clauses, be careful to cover all possible variations, right? Depends on whom you're acting for. So there is a difference between proposed and approved. So be aware of that. I think we can probably ask questions at the end of the presentation. Are we okay with that?
So can you clarify for everyone if it's
I
whoever
question.
on a title page or once it's approved, then buyer will pay?
So it depends what you put in a contract, right? In this case, it's written is a special levy is approved before the completion date. Then basically the seller will pay it, right? Here, that's what it says. But in my situation, the special levy was proposed, but not approved, right? So in this case, we can't really hold back because of the wording. If the contract is silent, then whoever is registered owner is responsible to pay. That is
Yep, I have a question.
Mhm.
I can't see what the original special assessment was, but does it make a difference if it's payable in installments? For instance, if the property is sold and conveyed after one payment, but not before the other payment, according to the way that the levy was written, it's due immediately, but payable over a course of time. Does that make a difference?
Mhm. So that was the previous situation, right? That we
Yeah.
looked at here. So that shows this installment. So because if we had this clause that clearly states that this entire portion is payable, the seller will credit the buyer, then it's all on the seller. It doesn't matter that it's in installments, right? It just
Yeah, because as soon as you pass the assessment, it becomes the responsibility of the seller.
correct, yeah, but you need to make
what I
sure
thought.
you're putting correct clauses in the contract to ensure so it's clear who actually pays that. So that's the message here, right? You can't leave, you can't, if it's a strata property, right? Don't leave it blank in a contract. And then let's
Yeah.
say if we have this situation like here, then you're putting your client at risk, right? Depends again whom you're acting for.
So in a situation, if let's say agent and everyone totally overlooked it, or they just want to play by fate, lottery, whoever wins in this case, right? They don't put it in a contract. In this case, how it will play out?
It will play by law, right? Strata Property Act will that's section 109. Maybe write it down and so you understand it. So this means it's payable whoever owns the property.
Yeah, whoever on a title at that moment, right?
At that
date.
moment, yeah,
Mhm.
correct.
Can
I
you
had
put a
it
clause
actually-
in the contract of purchase and sale that if the proposed levy is approved, that after acceptance of offer, or after can you put a clause in, and is it enforceable
Of course,
that
yeah.
the buyer pay it or the seller pay it? Sorry.
Yes, of course. Why not? It's a contract, right? Whatever parties agreed to.
Because I've had two different versions of this, and one of this one lawyer said that no, it's not payable yet until this time. I said, well, it says it's due, and the guy says, no, that's a violation of the Strata Property Act. In another instance, I actually, believe it or not, I actually organized the very first time special assessment was charged against unpaid strata fees rather than the title of the property. And I organized a loan to pay for the special assessment. And I ended up getting HSBC to
Anna, can you
pay
mute
it out
yourself?
because it was due and payable immediately, but there was a loan in there, right?
Mhm.
Another time they said no, and the buyer didn't want to argue. It was only like $5,000 or $6,000. So the buyer just said, just pay it and be done with it, right? But
Mhm.
was my opinion at the time that he shouldn't have had to pay it.
Mhm. Well, as you can see, right, it creates a lots of potential conflicts and disputes. So it's really important to whatever parties agreed in the contract, right?
Yeah.
and what's the intention of the parties. So I would say, yeah, be careful with these clauses, but
Yeah.
if it's clear, right, then like, for example, in my example here,
Yeah.
it's only covered approval, right?
Right.
Approved, but oftentimes we're dealing with those that are proposed to.
Right. You can't sign away your rights in a contract. If there's a statute law, which is what Strata Property Act is, you can't write a contract that conflicts with statute law.
Not really, not really. It's the Strata Property Act, this section 109, it gives you, if the contract is silent, then that what will apply. But
Okay.
if you can actually contract it out, right? And if you put a certain clauses there, if that's what parties agreed,
Right.
then yes.
To be really glib, you can put in the contract that the seller will provide their firstborn child but you can't enforce it, right? I'm being glib, I know, right?
All right, I'm happy that you ran into those situations and you already dealt with them. So just be aware of what the law says, right? And which specific clause you choose for your situation.
Right.
If in doubt, you can always, contact us. I love discuss and brainstorm some ideas. So we would love to look into that.
I find
It's
this particular
actually
subject fascinating, so.
It's actually happened to me when I was buying. There was supposed to be 10K allocated to my unit, some plumbing issues, and was supposed to be meeting in a place to approve that. And agent that represented me was trying to push it on a seller, and seller tried to push it on a buyer, which was me. Just a second. Мы сейчас на собрании, Мил, заходи.
In the case where the lawyer felt that he didn't have to pay, it was a foreclosure.
And what
That
happened?
might have had something to do with it, right?
What happened then?
Well, the buyer just
Seller-
said, no, I'm going to pay it. I don't want to argue. It's going to cost more money to fight it than it is to just pay the $5,000. So let's just pay it and be done with it, right?
Foreclosure,
Yeah.
it's different, right? It's very difficult to enforce to pay anything for the seller, right? But at the same time, you need to look at the order, right? So what's written there, what's payable.
Right. Cool.
But what happened? My seller went to this meeting and he make a big stink, big hysterics, and he pushed this discussion for after my completion. He was able to deal with the meeting at that time. So I had to pay it, but I was more or less ready to pay, but it was like that. So sometimes seller can go to meeting and influence those things. If he's successful, then buyer will have to pay it.
All right, so let's move on. Now we move to the holdbacks. It's important to recognize that there are two types of holdbacks that exist: statutory and contractual holdbacks. And guess what? You can't contract out statutory holdbacks. So that's where you can't actually go around that. So everything that's contractual, yes, you can negotiate and put it in a contract.
Natalya, because our meeting is kind of supposed to be about FinTrack, can we insert a bit of FinTrack discussions in this?
I wanted to prepare a little bit more information for you. I can, I can give you a few words, right? But I wanted a little bit to put more slides for it. And I mean,
yeah, it's okay. But if you can touch on it today, would be helpful.
Yeah, sounds good.
Because it's in our schedule, right? So you can say at least few minutes about it, so it will be also useful discussion.
Sure. All right, so here's example of the holdback clauses. So as you can see here, that's what was written in a contract. and there was a holdback about garbage removal. So seller covenants to remove all garbage and debris from the property at least 3 days prior the completion date. On the inspection day, the buyer may inspect the property, and if the garbage remains, then the buyer may hold back. So the most common problems that we see with the contractual holdbacks is that they're not written, they're written poorly, right?
Yeah.
If you're putting something like that there, make sure you provide some further resolution, right? How long is this holdback for? How the dispute is resolved? Because sometimes we have files that sits for years in our file system, and the holdback cannot be resolved, right? Because of the poor wording in the contract, and just parties don't have any resolution, right? And
What does debris mean?
right? Including vehicles, right?
Yeah, what does that mean? Does it mean like a paper bag on the floor? Like, what does that mean?
Exactly, right? So try to be really specific to what are you're trying to achieve there, and just make it, and think about it, and warn your client that those especially lengthy holdback that sometimes in the contract they will take years. The client will pay for that. It's additional cost to manage that. It's a trust money. They sits in trust account. There is a fee for managing this account. So it's, discuss all these potential issues with your client if you're running into that, right?
Anything subjective,
Exactly. So who knows what would be example of the statutory holdback?
Special assessment.
That would be non-resident holdback.
Right.
So if the seller is a non-resident for the purposes of Income Tax Act, this is something that by default will apply because it's a law. There is no way around that. And that would be basically between the closing solicitors to determine who will be holding this holdback. Also, sometimes we see the words in the contracts that we put, and holdback will be placed on a special account that will generate interest. So also be careful with those. It's very expensive to set up that account, and not everybody will do that. Not all legal firms will do that, right? So for example, at our firm, we will not create a special account. It will be just our general trust account, right? And interest earned on our trust account and everybody's trust account in the province, if we're talking about notaries public, it goes to the special fund, right? So nobody earns, it goes for a special fund that supports different programs, including legal aid.
I had the holdback happen to me as well. I was buying property with parking, and then during closing, my lawyer discovered that parking lot comes with a strata lot, and it's belong to a different unit, actually, not even developer. So what happened, this building was almost heritage since 1930 something. And this was situation for all units. Can you imagine, like so many deals went through, so many buy and sell, and everybody thought they have parking, but they didn't. So now it's in Supreme Court, this discussion. But my holdback already over because it was like 10K, so I'm not part of that because I didn't pay for parking as the result. So sometimes it's many lawyers can do mistakes for many years, and after one lawyer can discover this will be big case, actually, interesting case.
Yes, absolutely. I also want to cover some GST issues, as we also run into this quite often. So by default, if GST is not mentioned in a standard contract of purchase and sale, if it is applicable, then it's taxable on the top of the purchase price, right? So take away here from you, because in our standard contract, there is only one section, right? It's section 11B, that GST certificate will be provided at closing. So if you potentially, and we all know, right? So realtors cannot give GST advice. Notaries cannot give legal advice for GST because it's accounting, right? So you would, of course, put a proper clauses there advising your client to have GST advice, but it's good practice to start spotting it, at least, that it might come up. So that's why it's really important how it's worded. Sometimes we see clauses that if it's included, then it's part of the purchase price, right? So you're kind of already covering that here. So try to spot this in advance, protect yourself by adding GST related clauses. And you probably all know that after May 2022, assignments of contracts are taxable in respect of newly constructed or substantially renovated housing. So before it was depends on the intention, but now the consideration is now taxable. So that's now, there's no discussion for that, right? And sometimes the assignors, they don't know about that. And for PTT calculations, for property transfer tax calculations, also something to keep in mind, if it's a pre-sale, then what we've seen that Ministry of Finance might reassess the fair market value and actually come after the buyers a few years later, and because they think that fair market value is different. So that also happened before. I'm gonna skip that, but I already covered that GST on assignments is taxable. Keep in mind that most residential assignors are not GST registrants, so which means they will have to hire an accountant, right? And then to remit GST to CRA within 30 days of the completion of the transaction. So if you have assignment, keep that in mind, depends which party you represent, right? So audits, right? So different types of audit exist, right? Ministry of Finance doing the audits, FinTrack also, right? So doing its audits. Notaries public as well as real estate agents, FinTrack compliant. Like I mentioned, I'm going to cover a little bit today. If there is more interest to explore more in detail this subject with a quiz at the end, I can definitely put it together for you. But I can talk from my own
definitely
practice.
we have more interest.
Yeah, what we're doing, right? We have a special policy that we follow, and everybody in the office, they know, right, who is doing what for the purposes of FinTrack compliance, right? The first thing we is ID verification, and I can't stress enough for that verification how important that to ensure that your client has a valid ID, not expired, right? I had actually a case. It's went to the court, and it was my transaction where I represented the buyers, and I will send you the link later for that case to read. It's very interesting reading. But the story there, it was a foreclosure case. The story actually started with a real estate agent who there was a lot of things involved, but one of the things that was poor job was done, the realtor didn't check IDs, right? And that it was foreclosure, everybody were in a hurry, and the names were put wrong, which affected that the court order issued with the wrong names. Title went with the wrong names, right? Because we have to follow the court order. So at some point we had to revise a court order and revise the title. All of this just because the ID wasn't checked properly, right? And recorded. And sometimes we hear that people few days before completion and we're here for them, well, I don't have valid ID, everything is expired. So the question is, well, how then everybody else, when this transaction started, were checking these IDs, right? So it's really, really important when you do your part, make sure you record those IDs, right? What we do also here, we have, it's also about managing the client relationship, right? So it's always important to keep a notes in file. All our files have a record if it's a first-time client, if the client used us before, in which circumstances, what type of transaction. So it's all about know your client, right? So you have to assess the risk, right? By default, real estate transactions are all already medium risk transactions. It's not a low. So it's basically starts from medium and high, but we're going to talk about it later, how actually to put it together and what factors you need to look at in order to assess that risk.
Natalya, I have a question. Like, if your client has those expired IDs, then what would be the next step that you should take care, you should follow as a real estate agent?
As a real estate agent, right? So, I mean, first thing you have to tell them, well, go and update your IDs like now, right? You can apply for a driver license, right? It's quite a fast process. So at least for the completion, you already have a valid ID, right? For you, you need to make sure that this person is who it is. It's really identifying the identity of that person. So usually when we run into those situations, we will ask them to bring everything that they have, including birth certificates, right? The more it's better. In a rare case scenarios, somebody who known them for a long time can swear a statutory declaration confirming the identity of that person. So it's all about really satisfying yourself that that person is who this person is, right? So just gather everything what they have and tell them right away, go update your ID, go apply for passport in case they don't drive, right? So the sooner they start doing that, the better. Because some lenders, it's also potentially can be a problem at the completion because some lenders.
I have a question. Sometimes, like we were we have a discussion about like with other firms about in each firm sometime kind of some realtor not really, you know, they protective about the client list, and so in a FinTrack it is address of person, occupation, and also the
Yeah, that's a
name.
minimum, right? It's a minimum that you need to know your client, right? When we doing the transaction, we get to know lots of information about the client.
Do you happen across that a realty firm ask you names and number of the client because realtor didn't provide it to them? Will you release such information? Because actually it's a client of the firm, not of the realtor individually, exactly, right?
Correct. And I give you example that I had the situation when it was a transaction when I had a mortgage broker on the other side who didn't update the proper IDs from the client. We closed the deal. And after some time, the mortgage broker emails me and asks, oh, can you please send me the IDs of that client? I'm like, and why I should do that, right? So I cannot release these IDs. That's a private information of my client. Yes, she referred me that client, but I have privacy obligations to my client. I cannot release this information without the consent of the client. And guess what? When I asked her, why don't you get this information directly from the client? I don't know, there was something going on there. Apparently the client wasn't replying to her. So when I asked my client, can I release it? He said, no. So, and she now is not compliance with her documents because she must record the ID of the client, right, for the lender. So that's the real situation, right? And also I'll tell you situation, like I've been practicing for 6 years so far. I had to report once, FinTrack, do a FinTrack report for the suspicious transaction. So that was a purchase, cash purchase for, I think more than $2 million property. And the lady was, when she came and she filled in the form, and I asked, like, that's also part of the process to know the source of funds, right? Where the money are coming from. That's all FinTrack related. So we also have these questions there. What are the source of funds? So she said, well, it's my boyfriend who has some sort of, he doesn't live here. He is in a gaming kind of casino thing. So it was basically, yeah, this transaction never closed, actually. They've been always postponing it for almost a year, never closed. But there were lots of factors there that told me it raised my suspicion is a large cash transaction. And as your obligation, it's only to report, right? We don't, because FinTrack, it collects information, right? We don't know what they're doing with that. Our obligation is just to report. Client most likely, not most likely, they will never know. And we don't have to tell them that actually you reported that transaction, right? It's not your obligation to the client. So that's important to understand. So yeah, that's about FinTrack, but I'm happy to give you a little bit kind of more detailed information about that. I'm gonna ask you a couple of questions here. What do you think could possibly go wrong on closing? So here's the scenario for you. Buyer and seller enter into a standard contract. There is a fire at the property prior to closing. Does the buyer still need to close? What do you think?
Yeah, the property has to be in a similar condition of the day of viewing, right? So that creates an issue.
Okay, but do we still have to close?
Nazir, what do you think?
Yeah, they have to close it, but there is a barrier. Probably they lose the deposit.
Yes.
It'd be interesting because how can an insurer pay for the rebuilding of a property that they are not insuring? Like, understand, like if the buyer doesn't have the same insurance company, it's not the same client. I mean, will the insurance company still fix the property for the buyer?
So here how courts looked at it, the answer is yes, but with an abatement of price or transfer of insurance proceeds.
Okay.
So the standard contract contemplates that the seller assumes to the risk for the building on a property up to the closing date, then the risk transfer to the buyer on the closing date. So in court, in some cases, the court orders specific performance requiring the parties to complete the transaction. But yes, there will be price adjustment, right, to the value of the destroyed buildings. But there is a requirement to close. It's a contractual obligation, right? And just recently, it was last week, this scenario happened in our office. On the day of completion, the buyer's legal rep files Form A transfer, but do not receive mortgage money. Is it a breach of a contract?
Say it again.
So the situation that we had, that on completion date, we filed a Form A transfer because that was a requirement of the lender. So they needed to see filed Form A transfer in order to advance funds, but they failed to advance funds on completion date. So that's the situation that we had.
I know that developers kind of deal with it in advance. They say if you delay completion, 1,000 a day, they want to have it. So they would allow it, but for the price. And
Yeah,
it's
maybe
really
like granting an extension, right? So it wasn't a pre-sale. It actually was an interesting transaction. It was a farm. So what we did, basically, we filed transfer, and my lender, it was represented by a law firm, so I wasn't dealing directly with the lender. So the lender said, yes, it's all good. We're waiting for the money, you know, and time goes and we're like, where's the money? Well, we have a technical glitch. So the technical glitch happened, and well, we advised the other side, looks like there is a technical glitch, but you know, sometimes it happens. So technical problems, right? As long as there is still the same intention of the parties to complete, they do not constitute the breach of the contract. So it actually is allowed to file and pay the next day, but usually it happens like first thing in the morning. In our case, first thing in the morning, we still didn't have money. So the glitch continued up to the 24 hours since we filed the transfer. And then we're already entering into a situation where it's a noon time, there's still no money. The other side obviously questions that and starts to tell us, well, you have to withdraw your Form A transfer, right? Because, you know, you basically failed to get the funding. And they basically give us a timeline, right? So our client is willing to wait, let's say, till 3 o'clock. If we don't have money till that time, then you withdraw the transfer and negotiate extension. But let's say this is a way out for the seller. If they really want out, right, that's definitely a way out for them. In this situation, we received money at 2 o'clock. So we were able to deposit by 3. But it's definitely time of the essence situation. And it's very surprising that big banks can have these delays these days. So,
and you mentioned that you represent a private lender in such case, right? So what
well,
happened?
not in this case. In this case, I represented the buyer, and the lender was represented by a law firm.
What happened if something like this happened and last second they for some reason didn't get the fundings? In that issue you can help with in the last moment? Do you have like private lenders standing by ready to?
Well, it's all about if a client has plan B, right? But I don't think somebody, well, sometimes depends on the amount. Clients can get a private lending last minute. And we had this situation, there was a change of financing last minute, but at least you need maybe a day or two, right? Here it was like each hour was on account, right? So, I mean, if your client runs into this situation, yeah, definitely there are private lenders available and they can fund fairly fast. But of course, when you deal with private lenders, there's a lot price to pay for that.
Like it depends on both buyers and sellers if they both agree or the seller agrees to give them extension, right?
Correct. Yeah. But in my situation, we definitely didn't want to withdraw the transfer, right? Because that would create additional cost to the client. It's just now the whole new thing again, negotiate extension. It's just a lot more logistics around that, right?
I have that also happened to one client, and it was, credit union. I wouldn't say it was a bill lender. Exactly last moment, they approved the mortgage, but then for some reason, last moment they say to the client, we need 50,000 more. Then we, like they just want to give a less of 50,000 of funds. So luckily the client has that money ready, but what if he don't, right?
Exactly.
How it's gonna be?
And
I
we've
was actually
seen that.
shocked by such situation. I never thought it will be.
Yeah, we've seen those situations, so the client must come up fairly quickly, right, with those. And again, in this situation that we had, it was a big bank, right? It wasn't a big lender, it was a big bank. Anyway, so how to avoid conflicts, right, or litigation? So spot potential issues and send client to obtain advice or consult with your referral partner solicitor. Oftentimes we get the contracts to be reviewed before subject's removal date, right? And it's a good peace of mind that you can give to your client to make sure that they are comfortable signing that and they understand the terms. Check IDs, properly include names in the contract. So your client's interests are first. Do not remove subjects without proper documentation. So that's exactly what happened with one of those deals when we had to get the urgent financing because the subjects were removed before client got approval for the financing, right? So that was very stressful transaction for the client. Full non-financial charges at the stage of a due diligence process. So that's kind of my recommendations. And so question for you here, do you know if there is any difference between notary or lawyer when they act for real estate transaction? If yes, please speak out.
Nazir, do you want to try to answer this question?
A lawyer has a legal degree for one, but I think in notary public, you can just basically apply to be one, right? Like my parents were going to become notaries and they weren't lawyers.
Okay, any other answers?
It's a different what notary can do and what lawyer can do.
Okay, so I'll make your life simple. There's no difference whether notary public or lawyer represents clients in real estate transactions. It's also, it's a legal education, right? It's a master's degree that notaries receive, and only in BC, notaries can actually give legal advice. So that's very differs from different provinces over the country. So that's where your client's benefiting, right? If it's collapsing deal, they don't have to go to a lawyer to get the legal advice. It's actually, if it's a notary who's closing, it's obligation of the notary to provide legal advice to the client. And if it goes to the litigation and they need to hire legal rep, that's where they will need a lawyer because notaries cannot go into the court, right? So that's the only time when lawyer will be needed. Otherwise, yeah, legal advice for those are included, and it's already included usually in the service. So something that you hopefully learned today. So let us complete your client's deal by adding Uptown Notaries in your list. We've been approved vendor for many brokerages in BC, and we're happy to answer your questions if you're at the stage of putting the deal together. This is our contact information. So we have Burnaby and US office. Make sure you follow us on Instagram. As Natalya mentioned, I share some important tips about deals that we have on a daily basis and how we overcome them, what solutions we have. So something maybe that you can learn and use in your own practices. So thank you for listening. If you have any further questions, I'm happy to reply.
Thank you, Natalie. I need to go. Have a great day.
Have a great day.
Thank you.
Thank you.
Thank you, Natalya.
You're welcome.
So was that the FinTrack thing that we were to be what?
Yeah, we
there
touch
more?
a bit of FinTrack, and Nilam may have some more discussions.
We will do FinTrack part 2 because, like I mentioned, I need a little bit more time to get more into the depths of this subject. So we can do like maybe this was contract issues, FinTrack part 1, and we can do separate for FinTrack part 2.
We have a meeting every Tuesday at the same time, once a week. So which one you would like to attend, like next week or after?
Look, since you got me here. Like my Tuesdays no. So the first Tuesday that I have would be are you guys still operate in December? Like
Yeah.
December, yeah. So it will be December 17th.
Okay, good. So maybe I'll put it in our schedule so we give announcement. Great. Yeah, it's a good we discuss FinTrack monthly.
Perfect.
Thank you so much. And we have a question about private lenders. So do you help with that if realtor need a client that need a private lender?
So basically the way I get into this, I usually legally represent the lender on closing. I prepare all paperwork, but I also have access to, my private lenders who lend money for the real estate transactions, right? I'm not a mortgage broker, but I have some connections that I can explore if we're talking about the money needed. But on the legal side, I do the paperwork for them.
Great. And would be able to share with us those connections so we are aware of more?
Yeah, for sure. I can ask him and I can maybe email introduce you.
Thank you so much. Yeah, okay. See you on 17.
Okay,
Very good
Thank
presentation.
you for having me.
Thank you. Thank you, Natalya.
And Nilama would like to
I
explain
think,
it a bit.
Natalya, it is already 10:40, right? So our meeting was supposed to end at 10:30, right? So if you want, we can add something, but otherwise.
Yeah, and we don't need to be a long discussion, just a little bit, yeah.
So we can talk about something like these days because clients are not present, right? So for that reason that we need IDs to see. Sometimes we don't know. We are not sure if these IDs are their own IDs, or how would you identify if it is the same person or the same entity, right? So then what would you do?
Yeah.
Like you are getting they are sending you their IDs, but that way, like the BCFS says that you can have a video chat with them as a next step to identify if the person is similar that you are seeing in the photo, right? So, or ask the person to take a selfie photo using the camera on this mobile phone or electronic device, and use an application to apply facial recognition technology to compare the feature of that selfie to the photo on the authentic government issued ID they sent you. So this is something these days, because we don't see our clients often, right? So then we can ask them to send us a selfie, or you can arrange a video chat with them to authenticate their IDs.
Okay, great. Thank you so much.
So let's do it next week, right? So for the next FinTrack meeting, right? So she has told us a very valuable information today. So we'll do our discussion next week for the rest of the points for the FinTrack, right? So the most important is know your client, identify your client. If they are not giving you their IDs, they are reluctant to give their IDs to you, then this is an alert to watch, right? So why they are not giving you their identification, right? So it means it could be an alert sign. Sometimes they are hesitant, right? So like the other day, I was at a showing for a rental property. So I asked this guy if it's okay to give me his ID. He said, no, I'm not interested. Then you know that when it is going to happen, when he's going to file the application, so then he may give you his ID at that time, right? So sometimes initial meeting is not always that they'll give you their IDs and stuff. That's when they're in the process, they will definitely provide you. But if they are not giving you, then this is an alert sign that what to do the next step, right? So we will discuss about all these things in the next meeting. So
thank you so much. Okay. So
Hey, Natalya, before we go, I'm looking for where I would find in, you've sent me these billings forms, and I'm looking for where there are the owner management contracts. I can find one it's like a tenant placement, but not a management contract.
Okay, Alex can show it to you.
Okay.
We will finish now.